Well, good morning. I trust you can all hear me. Good. It's now 10 o'clock, so would you please silence your mobile phones? This inquiry is now open. My name is Paul Clark. I'm a Chartered Town Planner. I've been appointed by the Secretary of State for Levelling Up Housing and Communities to conduct this inquiry. It's an inquiry into an appeal by Messrs G.P. Smith, G.M. Smith, G.W. Smith, G&K Groundworks Ltd and ACT Roadways Ltd, made under Section 78 of the Town and Country Planning Act 1990 against the decision by Castle Point Borough Council to refuse outline planning permission for 68 residential units, 3 Class E commercial business and service units, 1 B2 general industrial unit, and 2 B8 storage and distribution units with associated access, parking, amenity space, strategic landscaping, noise attenuation, restoration and improvement of existing estate roads and infrastructure on land east of Manor Trading Estate, Benfleet, Essex, SS7 4PS. The acoustics here are good and we've got public address, so advocates can remain seated when speaking. In the event of an emergency and the need to evacuate the room, follow council officers' instructions. People should feel free to come and go while the inquiry is in session, but please do so quietly without disturbing the proceedings. The application is made in outline. Details of access are to be considered now. Details of appearance, landscaping, layout and scale would be considered at a later date if permission is granted. The proposed development was screened by the Secretary of State in accordance with Regulation 14.1 of the Town and Country Planning Environmental Impact Assessment Regulations 2017. A determination was reached that the proposed development is not EIA development. There is therefore no environmental statement required, nor any parameter plans to be imposed by condition in the event of permission being granted. Now, I shall now take the names of those wishing to speak. So who speaks for the appellant?
Good morning, sir. My name's Emma Dring of Council.
Sorry, Emma?
Emma Dring, D-R-I-N-G.
Emma Dring.
And I represent the appellant. I don't know if you want the names of my team.
Yes.
I obviously gave them at the CMC. But,
you were. But yes, introduce your team. Well, tell me the names of witnesses you'll be calling and the order you'll be calling them in.
yes, so I'll be calling Justin Bass, who actually isn't with us today, but he'll be dealing with transport. And Josie Nixon, who deal with noise. She will be called today, hopefully, if we get to that point. And Russell Ford, who will deal with planning. And so, sorry, yes, it will be noise, transport, then planning, in terms of order. Thank you.
And my apologies to Mr. Bass for spelling his name wrong on the programme. With a name like mine, you'd think I'd be sensitive to that sort of thing, wouldn't you? Because
I'm sure he'll forgive you, sir.
So it's Bass without an E and Ford with an E and Clark without an E. Okay. So who speaks for the council?
So good morning, I do. It's Mr. Ranatunga, no E's in that name. It's R-A, N for November, A, T for telephone, U, N for November, G-A. And I'm of council, and I'm instructed by Jason Bishop, who's the head of law and deputy monitoring officer at the council, Castle Point. And so in terms of witnesses, I'll be calling Edward Davis, which is D-A-V-I-S, and that's on noise matters. And then on planning and other matters, including parking, I've got Alison Hutchinson.
Is there anyone else who knows that they want to speak during the inquiry? No? Good. Is there anyone from the press here? No. If anyone wishes to record or broadcast the proceedings on social media, feel free to do so, as long as you don't disrupt the proceedings. I believe everything is being streamed anyway. But if you are using a person's image in any broadcast you make, it's polite to ask them first. I have copies of the council's letters of notification of the inquiry and of the date, time and place of this inquiry. I've got 12 representations made in response to those, and I also have copies of 96 representations made at the application stage, which of course I take into account. I've got proofs of evidence from Josie Nixon, Justin Bass and Russell Ford for the appellant, and from Edward Davis and Alison Hutchinson for the council. Are there copies of those available for members of the public?
Certainly, we'll check, sir. If I believe they are, but I'll need to check that and get back to you.
Not that there's only one member of the public present at the moment, but there may be others turning up, and it's always helpful to them to be able to follow the proceedings by if they've got a copy of the evidence in front of them. I understand that a statement of common ground was in preparation, but I have not received it. And for the benefit of the member public who is here, statements of common ground are set out matters on which the signatories are agreed, but that does not mean that people who are not signatories can't raise other matters, nor does it mean that I necessarily have to agree with the matters on which others have agreed. But in any event, I haven't got a statement of common ground as we speak.
So just to give you an update on that, I've spoken to Ms. String this morning as well. I think the last version we received was yesterday, Sunday night. And obviously there was travel moving yesterday. We are looking at it. It is somewhat more advanced than previously. We're hopeful we can get it agreed during the course of this inquiry. Obviously there's been the logistics of arriving here, but since we did the CMC, I think there's been a couple of back and forths, haven't there? So it has been moving. It's just the latest iteration which we're looking at.
Okay. Thank you. The application is supported by a plethora of documents, but first I need to check that I have got the right plans, such as there are. I've got a location map, which is drawing number 163839 DPM006. I've got a location plan drawing number 163839 DPM005 revision D. I've got an existing site plan drawing number 163739 DPE102. And I've also got a proposed residential access and egress junction, which was submitted by email on the 24th of February, drawing number IT 1932 TA02 revision C. And as I said, there's a number of supporting documents, including a development master plan. I've got the original, got a revision B, and I believe the most recent version is revision C, which is included in Russell Ford's proof of evidence, together with a schedule of commercial building floor area and parking provision. I think I read somewhere in the council's material that you're happy with to proceed on the basis of the most recent documents. There's no issue about
Correct,
that.
sir.
Yeah, thank you. There's also, in addition to those drawings, there's a contamination assessment, a geotechnical report, a flood risk assessment and drainage strategy, a tree survey, an arboricultural impact assessment and arboricultural method statement, a transport assessment, an updated preliminary ecological assessment, a waste infrastructure impact assessment, a third-party response statement, a facade noise exposure assessment, and a planning, design and access statement. Some of those documents make recommendations which would have to be secured by condition if thought necessary in the event of the scheme's approval. Now, just a word about procedure. This is a planning inquiry and there are rules to be followed, though one of the rules is that I can change the rules to suit the circumstances. At the party's request, I have done that in respect of the order of business. So the order of business is, following my opening remarks, I will identify what I believe to be the main issues. Then I will invite the two main parties to make brief opening statements, if they desire. Appellant first, counsel second. And then, as I say, at the request of the two main parties, I'm going to conduct the inquiry with noise considered first as a self-contained topic. This means that, in effect, there will be a succession of two inquiries, the first one on noise, and then the second one on the scheme in general. In each session, I will ask the counsel to present its case first, and the appellant's advocate may cross-examine the counsel's witness. I may have some questions of my own. If there are any third parties wanting to speak or ask questions, they can ask me to put questions on their behalf, and then the counsel may re-examine its witnesses. Then I will hear from third parties supporting the counsel, if there are any, and I will invite them to be questioned if they do want to speak. And then I will ask the appellant to present the appellant's case. Counsel may cross-examine the appellant's witnesses. I may have some questions of my own, and third parties supporting the counsel can ask me to put questions on their behalf, and the appellant may then re-examine witnesses, and that procedure gets repeated for each part of the inquiry. So following the two successive inquiry sessions, there will then be a round-table discussion of potential conditions in the event that the appeals are allowed, and everyone can participate in that. That session does not prejudge the decision. It does not weaken or strengthen anyone's case, but it does need to take place when everyone is present. And then I will invite closing comments, firstly from the counsel, and then from the appellant, who has the final say. And if I can be provided with a written copy of closing comments, that will be helpful. Otherwise, you have to deliver them at dictation speed. And if anyone wishes to make an application for costs, it should be done at that point. I have visited the site, but I will make arrangements for a further site visit, accompanied by representatives of the council and of the appellant, either at the end of the inquiry or during a convenient adjournment. Or if everybody agrees that a further site visit isn't necessary, and you're happy with me having seen what I saw yesterday, then we can skip that. But I'm assuming that you will want me to go on a site visit accompanied. Third parties can attend that site visit, provided the landowner consents to their presence on the land. Unlike a hearing, I will not accept any evidence or submissions made during the site visit. All the evidence that I will take into account must be heard here in this room. This is expected to be a 4-day inquiry, and the main parties have given me an indication of how long they might take in presenting their cases, and on that basis I have prepared an approximate programme, which I expect to be roughly as follows. The council's noise case this morning, probably spreading into the afternoon, and then the appellant's noise case, and I hope we will finish on noise today. Tomorrow we will start with the rest of the council's case, followed by third parties supporting the council, if there are any, and we will start to hear the rest of the appellant's case, which we will conclude on Thursday, again followed by third parties supporting the appellant, if there are any. The round table discussion on conditions and the Section 106 planning obligation will take place on Thursday afternoon, and if we need a site visit, that'll be on Friday morning, followed by the closing submissions. And then I hope we'll conclude by lunchtime on Friday. So are there any procedural points on which anyone is not clear? Mr. Manatunga.
So just one comment to make on relation to the timetable. I think emails were sent last week about closings with the agreement of both parties about whether you would accept closings in writing. I know that that's something that's favoured by the inspectorate, and I think you've mentioned it this morning, and whether we would do that to an agreed timetable after Friday. Part of the problem that both myself and my learned friend have is, as ever, having to draft the closings as we go.
Yeah.
And we'd come to an agreement last week that we weren't going to do that. And I thought that had been, I think in your most recent timetable I'd seen, I think you had allowed for it. But the actual dates were not fixed, but we can obviously discuss that.
Yes. Do you have a view on that?
No, I mean, obviously, as Mr. Ranatunga says, we discussed it and we're in agreement. I think it doesn't necessarily serve anyone well for us all to be working until 3 o'clock in the morning and that sort of thing, drafting these documents. So if that was agreeable to you, obviously with dates to be fixed, then obviously I'd support that.
Yeah. The most recent iteration of the programme, I had put the site visit on the Friday morning, which will give you a couple of extra hours. But I appreciate that advocates are always in difficulty in summing up at an instant's notice, and I think it really depends on the amount of public interest, because if there are lots of members of the public, they would like to hear you reach your conclusions. If there are no members of the public, then I'm happy to have it all in writing. So shall we see how it goes?
Could I suggest a sort of possible third option, which is that if you consider that members of the public ought to, if there's in public interest and people should hear it, we could still potentially have a gap to write them and perhaps reconvene virtually to deliver them so that members of the public are able to attend remotely and hear them. I'm not suggesting that that's something that we need to do, but just floating that as a third way.
That's an interesting suggestion, Mr. Ranatunga. Do you have any views?
Yes, I'd agree with that. I mean, I would say that having agreed with Ms. String that we would do them in writing after the event, I haven't done the work that I might otherwise have done to produce them for Friday. So I would be in difficulties if you were to go down that route, and I can see Ms. String nodding. So I think to protect against the point you raised, sir, absolutely, if there needed to be a public airing of the closings, I would favour doing that online, as we did with the CMC. Okay,
well, we'll see how we go. As I say, there was some indication in the material submitted that there would be some public interest, but it hasn't shown itself yet. So we'll see how it goes. As I say, if there is minimal public interest, then I'm happy to just deal with it in writing. But we will have to agree a timetable, and I hope it won't be too prolonged, because I don't usually start writing until I've got your closing remarks from both sides, because obviously I don't want to start writing a decision and I have to rewrite it.
I don't know if I can indicate. I mean, certainly for my purposes, I'll agree it with Ms. String. I'll seek to agree the position, but the week after is certainly what I no later than the week after to provide both sets of closings was what I was envisaging. And I was thinking Wednesday, Thursday, but I will discuss with Ms. String.
Yeah. The usual convention is that yours will be presented first, and then a certain amount of time given for Ms. String to respond. And as you say, I certainly would like to have both your comments available to me at least by the middle of next week. So I'll leave that thought with you. All right. Any other procedural points on which... No? Okay.
Well, it's not really a procedural point, Per, but, sir, but Just in terms of the room layout, I don't know if I should address this now, because when we came in, there was a discussion with, I'm not sure, somebody from the council about where witnesses were going to go.
Adam, yes.
And yes, and it was suggested that they would go
Yeah.
on either side. I just wanted to flag, obviously, when we're examining in chief for myself and Mr. Anatunga, that will mean that our witnesses are effectively behind us.
Yes.
So I just wanted to raise the possibility of, I would be happy if you would be, for witnesses to just take it in turns, and then we can all be looking, and then you can see them more easily as well, sir.
Yeah.
Obviously, entirely a matter for you, but it just struck me possibly slightly awkward with the layout.
Yes. Adam has made provided us with a short microphone on either side, so the witnesses could go there. I can see them. The opponents can see them. I appreciate, assuming your witness was there and Mr. Mantonga's witness was there, you'd have your back to them to some extent. I'm happy with them over there. I can see them. You can see them. Yes.
So yes, I think the advantage is with the microphone, if there was anyone in the public who wanted to hear, they'd hear it anyway. Yeah. And it's advantageous for the main parties for examination in chief more than anything else. Having to examine in chief like this is a bit awkward.
Yes. Ms. Dring, did you want to add anything?
No, thank you.
Okay, well then, unless there's any technical difficulties, we'll have the witness sitting over there then. Yeah, good. Okay. So no other procedural matters? No. Oh, just to say about you probably realise that because the event is being streamed live, you won't be heard on the live stream unless your microphone is on. So do remember to switch your microphone on when you speak. I think it is possible for my microphone and the two main advocates' microphones to be on at the same time, but not for the witness's microphone to be on as well. So you'll need to remember to switch yours off when you want to hear the witness. Okay, so the main considerations then. I think it's common ground that by definition the development would be inappropriate development in the green belt. Therefore, based on the material currently submitted, the main issues in this appeal appear to me to be firstly the effects of the proposal on the openness of the green belt, secondly the effects of the proposal on safeguarded waste disposal sites within the adjoining Manor trading estate, thirdly the effects on the proposal of noise from the Manor trading estate, fourthly the effects of the proposal on the supply of and demand for parking for commercial uses, that is. Fifthly, whether there is an adequate supply of employment land in the area. Sorry, did I say fifthly? That should be. Fifthly should be an adequate supply of housing land. Sixthly is the adequate supply of employment land. And seventhly, whether any harm to the green belt by reason of inappropriateness and any other harm would be clearly outweighed by other considerations so as to amount to the very special circumstances which government policy requires to justify the proposal. And we'll also look at any benefits to be weighed in the planning balance. So, I now invite the appellant's opening remarks.
Thank you, sir. I'll just hand these out. I'm afraid my printer gave up on me last night, so I don't have multiple copies, but sir, I do have one for you, and I've got one for my learned friend. And we can provide obviously electronic copies. The appeal scheme represents an opportunity to deliver 68 new homes, of which 50% would be affordable, along with modern Class B2, B8 and E units. The site adjoins the existing built-up area of South Benfleet and is bound by the Manor trading estate to its west, Heston Lodge and Robert Drake Primary School to the south. There's existing residential development to the west and northwest. Developing the site would be a logical extension of the urban area and would effectively amount to infilling. The site is the only realistic area into which Manor Trading Estate can expand. A modest expansion at the northwest end of the estate is proposed, which would be accessed through the existing estate. The rest of the appeal site would deliver the new housing and 3 Class C units and would be accessed via Church Lane. In an ideal world, new housing development would be plan-led, but the current development plan is hopelessly out of date. Adopted in 1998, it's now a quarter of a century old. In 2018, the Secretary of State threatened to intervene, noting that the council had failed to meet milestones in published local development schemes at least 5 times since 2004, and 2 failures to take a plan through examination. The council subsequently spent time and money developing a new local plan, which was examined and found sound, only for the council to abandon it in July last year and go back to square one. There will be no new development plan in place until March 2026 at the earliest. This failure of plan making is reflected in the council's housing land supply position and record on housing delivery. The council has a land supply of only 1.86 years, and the position is forecast to worsen. The council has delivered only 48% of the required homes in the last 3 years. This persistent under-delivery is the default position in Castle Point. The council has only delivered 44% of the required housing over the last 17 years. Most shocking of all, the council has delivered no affordable housing at all in 2 of the last 3 years. The failure to adopt a sound local plan leaves the council without any strategy to address these significant challenges. This leaves the council in a dire situation, and the losers are the individuals who want to find somewhere affordable to live in Castle Point. Given the situation just outlined, it goes without saying that the provision of 68 new homes is a very significant benefit of the appeal scheme, and it's common ground that it must be given substantial weight in the planning balance. The council now begrudgingly accepts that substantial weight must also be given to the provision of 34 affordable homes, which would be secured by the Section 106 agreement, having previously afforded only limited weight to this benefit. The adopted development plan does not require any percentage of affordable housing at all, stating only that where appropriate the council will seek to negotiate a proportion. The adopted SPD seeks 35% affordable housing. The scheme would deliver 10 more dwellings than the SPD requires, and that additional number alone is not far off what the council has managed to deliver in the last 3 years across the entire borough. Chelmer Housing Partnership has confirmed an interest in purchasing the site and developing it for 100% affordable housing, so there is clear potential for an even greater contribution to this unmet need. The appeal scheme also provides a unique opportunity to secure the delivery of desperately needed improvements to the Manor Trading Estate. The need for this will be obvious from your site visit. There are 2 key elements to the appellant's proposals to pump prime investment in the estate. The first element is the improvement of the roads. These are in an appalling state and represent a significant liability for the owner, ACT, one of the appellants in this case. Planning permission is in place to remedy the defects and bring the roads up to an acceptable standard with proper marking and lighting, but this is costly. The appeal scheme will deliver profit, which can then be applied to the implementation of the planning permission. Delivery would be secured by the Section 106 agreement. Once the roads are brought up to an acceptable standard, ACT intends to implement parking control measures to address some of the egregious examples of poor behaviour which can currently be observed. Although this can and would be done anyway, a draft condition is proposed to secure this. The second element of the appellant's proposals is the phased regeneration of the Manor Trading Estate, which they intend to kick-start through the provision of the 2 new B8 buildings and 1 B2 building. These will be modern buildings fit for modern purposes, in contrast to much of the ageing stock found on the Manor Trading Estate at present. The appellants envisage that existing occupiers of the large building at 30 Brunel Road, which includes 3 of the appellant's family businesses, would be given first refusal to move into the new space. This would then free up space in 30 Brunel Road, and so on. It's intended that this would kickstart a process of investment and upgrading within the estate, allowing plots to be freed up and improved or redeveloped. Aside from the appeal scheme, no other mechanism exists to deliver the council's long-standing aspirations to improve the estate. This is a benefit which must also carry substantial weight in favour of the scheme. In addition to the 3 key benefits just identified, the appeal scheme would deliver a range of other benefits, including 5,874 square metres of new employment floor space, estimated to equate to 50 full-time jobs, construction jobs, contributions to the local economy from new residents and new employees, improvements to the current noise environment experienced by the nearest sensitive receptors, 10% biodiversity net gain, increased and better located parking spaces for use at school drop-off and pick-up time, and a new pedestrian crossing subject to agreement with Essex Highways on location. All of these attract positive weight in the planning balance. Inevitably, the appeal proposal is inappropriate development in the Greenbelt and will cause harm to openness and to Greenbelt purposes. But if Castle Point is to meet its housing need, around half of the homes required will need to be built on Greenbelt land. This was the conclusion of the council's own evidence base, supporting its recently withdrawn local plan, and the inspector found that it provided the exceptional circumstances necessary to alter the boundaries of the Greenbelt. In its withdrawn plan, the council proposed 12 housing allocations in the Greenbelt. In every case, the inspector found exceptional circumstances for releasing land from the Greenbelt. The balance to be struck between the Greenbelt and the need for housing was clear. That was in the context of a local plan examination, and this is a Section 78 appeal, but the essential balance is no different. The council is firmly in the midst of a housing crisis of its own making. It's patently obvious that there can be no hope of resolving that crisis unless appropriate Greenbelt sites are used to deliver housing. The appeal site is such a site. In the council's own words, the rural integrity of the site is compromised, development would broadly constitute urban infilling, and the site can be removed from the Greenbelt without undermining the purpose of the Greenbelt in this location. No doubt if this site had been progressed as a housing allocation as originally proposed, it too would have been found sound and released from the Greenbelt. The harm to the Greenbelt must be given substantial weight, but the extent of the harm is modest. Set against this are some very weighty benefits indeed. The combination of those benefits aggregated together easily provide the very special circumstances required for permitting an appropriate development in the Greenbelt. The appeal site is located immediately adjacent to a metal recycling facility operated by Benfleet Scrap. Noise from the scrapyard is clearly audible on site during its hours of operation. That does not mean that the site is not or cannot be made suitable for housing development. The council recognised this in the 2018 SHLA, and more importantly through the draft allocation of the site for housing and employment uses in 2018. Clearly, noise from Benfleet Scrap was not thought to be an insurmountable issue. The appellants have commissioned a full noise assessment, which confirms that the guideline internal noise levels contained in BS 8233 can be met. This does not depend on all residents keeping their windows closed and relying solely on mechanical ventilation. It will also be possible to meet the upper guideline for external amenity areas of under 55 dB across the whole site. In fact, the desirable under 50 dB guideline level will be achievable in most places. The BS 4142 assessment provides an indication of adverse impact based on the differences between the rating level and the background sound level. However, when regard is had to the context, including crucial design measures such as acoustic screening, facade insulation and glazing specifications, which can be secured at reserve matters, this does not present any barrier to development. The council have proposed conditions which would require specified sound levels to be achieved inside dwellings and in external amenity areas. There is disagreement over the appropriate sound level for external areas. However, in principle, these conditions should provide the answer to any concerns about noise. They will ensure that no homes can be built and occupied unless the appellant can demonstrate that those levels will be achieved. That is an entirely appropriate approach at outline stage, where the final layout and design remains unknown, and will avoid any risk that prospective residential occupiers will be exposed to unacceptably high noise levels. Policy 2 of the Minerals and Waste Local Plan exists to ensure that where development is proposed within 250 metres of a safeguarded waste facility, the Minerals and Waste Planning Authority is notified and can decide whether to object. Concerns about the impact on Benfleet Scrap flow directly from the council's view as to the likely effect of noise on prospective residents. Because the council considered that an acceptable noise environment cannot be achieved for the appeal scheme, it is suggested that justified noise complaints would be likely. The council's concern is that such complaints could result in Benfleet Scrap's activities being curtailed. The appellant's evidence is that the noise environment for prospective residents would be acceptable, and indeed better than what is currently experienced by the closest noise-sensitive occupiers. There is no proper basis for concluding that complaints are likely. The history of complaints provided by the council, such as it is, does not support such a conclusion. Furthermore, the appellants are clear that Benfleet Scrap currently operates outside the terms of its environmental permit, and using practices which are unnecessarily noisy. This creates a falsely elevated baseline. Whilst unreasonable restrictions should not be imposed on existing businesses per paragraph 187 of the framework, it's plainly not unreasonable to expect them to operate within the terms of their permits and in a responsible manner. The level of parking provision should be a non-issue. It's highly unusual for a scheme to be rejected at outline stage for reasons relating to parking, and there is no basis for suggesting that an acceptable level of parking provision cannot be achieved at reserved matters stage. Revision C of the illustrative master plan shows that an acceptable level of parking can be achieved based on the 2009 standards, with the dimensions favoured by the council and adequate provision for disabled parking, powered two-wheelers and cycles, as well as spaces for commercial vehicles. It appears from the Statement of Common Ground process that following receipt of Revision C, the Council's concerns about displacement of parking within the Manor trading estate may be the only outstanding issue. This will be explored in evidence. The Council seeks to place considerable weight on a restocking notice issued on the 13th of February 2023 under Section 17A of the Forestry Act 1967, which on its face requires trees to be planted in 4 areas of the appeal site, and in particular an area which cuts across the Class E buildings shown on the illustrative master plan, which for the purposes of the noise assessment have been assumed to incorporate a 12-metre sound barrier within their rear wall. Full submissions on the notice and its implications will be made in closing. However, 3 basic points will be advanced. First, it's not accepted that the restocking notice is a material planning consideration. Generally, restrictions arising from other statutory regimes are not material considerations. And I've referred to 2 cases there, and I'll obviously provide copies of those, sir. Alternatively, even if the restocking notice is capable of being a material consideration, it should be given limited weight. The Court of Appeal in the Arnold White Estates case considered that a power to amend or withdraw a Section 24 notice may exist in limited circumstances, including where some inaccuracy or ambiguity had occurred in its wording. That conclusion applies equally to a Section 17A notice. It would be contrary to good administration if obvious errors could not be corrected. When accurately measured, the restocking areas shown on the notice cover nearly double the area of land identified by the reference committee as being required to plant the 183 trees specified in the notice. There are also clear procedural fairness issues. For example, there was no opportunity to comment or make submissions on the proposed restocking areas as part of the appeal. The appellants have already begun the process of seeking to negotiate with the Forestry Commission, and if that's unsuccessful, will seek to challenge the obvious errors by judicial review. In the circumstances, limited weight can be given to the current notice. And then thirdly, this is an outline application. The focus at this stage should be whether the principle of development is or can be made acceptable. Clearly, some form of noise attenuation will be needed, but there are likely to be alternative technical solutions even if the Class E buildings cannot be built. Similarly, it will be possible to amend the illustrative residential layout. Proposed noise conditions will ensure that whatever happens, specified noise levels will have to be met internally and in external amenity areas. If the appellant's efforts to negotiate or challenge the restocking notice fail and no alternative noise attenuation measures can be found to achieve compliance with the conditioned noise levels, then the development will not be able to proceed. That's an appropriate way of dealing with the issue. So in conclusion, there's no basis for refusing planning permission on grounds of noise or parking, bearing in mind that with appropriate conditions, both matters can be addressed in an acceptable matter at reserved matter stage. The real issue in this case is whether there are very special circumstances for permitting development in the Greenbelt. The appellants will demonstrate through the evidence that there clearly are, and in due course will invite you to allow the appeal, sir. Thank you.
Thank you.
So this appeal turns on whether the appellant can demonstrate that there are very special circumstances associated with its proposal which clearly outweigh and justify the considerable harm which it will cause to the Greenbelt. The appeal scheme will introduce new development in the form of 68 residential units and 5 industrial units, that's 3 Class E, 2 B8 and 1 B2, into the Greenbelt between South Benfleet and Thundersley, which the appellant accepts is inappropriate development and harmful to the Greenbelt. a matter which carries substantial weight in the planning balance. The appellant also accepts that the appeal scheme will give rise to harm to the openness of the Greenbelt. The fundamental aim of Greenbelt policy, of course, is to prevent urban sprawl by keeping land permanently open. There are a number of other elements of harm. The appeal scheme will not result in an acceptable level of amenity for future residents. There is an increasing importance on good design in the framework, ensuring developments will create places that promote health and well-being with a high standard of amenity for future users. This objective will not be met by this proposal. It will also impact on safeguarded waste management and infrastructure sites within the Manor trading estate adjoining its western boundary, and will not integrate effectively with these existing businesses. The parking provided will be inadequate given the current pressure on parking on the Manor trading estate and the need to mitigate for it. The Council's planning officers understood these points and refused planning permission for the proposal on the basis of the following reasons for refusal, and that was back in May 2022. I just outline those in summary. Firstly, the proposal represents inappropriate development that is by definition harmful to the Greenbelt and will only be permitted if very special circumstances exist to clearly outweigh the harm. No very special circumstances have been demonstrated, whether in isolation or in combination, to outweigh that harm. The proposal fails to adequately identify and consider the impact of the proposed residential and commercial development on safeguarded waste disposal sites within the Manor trading estate. The submitted noise constraint survey and facade noise assessments fail to adequately demonstrate a lack of adverse impact arising from the operation of sites within the Manor trading estate on future occupiers of the proposed commercial and residential development. The submitted noise constraint survey and facade noise assessments fail to adequately demonstrate a lack of adverse impact arising from the installation of the proposed acoustic barrier on the western boundary of the site on premises and operations within the Manor trading estate. And then the proposal fails to demonstrate the provision of appropriate car parking, powered two-wheeled vehicle parking and cycle parking facilities for the proposed commercial units. Further, the applicant has not adequately demonstrated that the proposed development will adequately mitigate its impact on the existing parking provision within the adjoining Manor trading estate. The full reasons for refusal are set out and clarified in the Council's statement of case, that's 9th of January. In particular, it will be noted that reasons for refusal 2 and 3 are taken together and are directed at the proposed acoustic environment and the likely effects on future occupants of the appeal site and in existing industrial businesses. Following the instruction of Edward Davis to provide expert noise evidence for the appeal, the Council indicated on the 4th of January of this year that it would no longer pursue reason for refusal 4 on the failure to demonstrate a lack of adverse impact arising from the acoustic barrier. As to the effect of the proposal on the Greenbelt, including openness, the Council will rely on the evidence of Alison Hutchinson, who's a partner at Hutchinson's. Mrs. Hutchinson had no prior involvement in the Council's consideration of the scheme at the application stage and comes to it with a fresh set of eyes. She explains that the appeal site forms part of the Greenbelt, fulfilling 3 of its purposes: checking unrestricted sprawl, preventing the merger of neighbouring towns and assisting in safeguarding the countryside from encroachment. There is in principle harm to the Greenbelt here. In addition, there will also be harm to openness. The proposal will be totally out of character with the housing development to the east. The northern part of the site, proposed for industrial development, is completely open visually, and the site provides an open rural area of land between the more intense development of the industrial estate and the low density and wooded plotlands located to the east. The proposal would remove and harm the openness of this part of the Greenbelt. As to the noise impacts, the need for extensive noise attenuation is apparent to anyone who visits the appeal site. It shares its western boundary with the Manor trading estate, an industrial estate since before 1949, made up of predominantly B2 uses, but also some Class E, B8 and sui generis uses, including safeguarded waste sites, most of which are reliant on external working and storage. One of those safeguarded waste sites is Benfleet Scrap Limited Company, and that's at Unit 16, which is a long-established open scrapyard dismantling cars and recycling various metals. The appeal site experiences considerable noise pollution because of its close proximity to the Manor trading estate and Benfleet Scrap in particular. The Council's evidence on technical noise matters is given by Edward Davis. He has undertaken a site view and reviewed, amongst other things, the Facade Noise Exposure Assessment Report, that's version 2, of HA Acoustics, dated the 6th of April, and submitted in support of the planning application. Mr Davis raises significant concerns as to the noise environment for future residents of the proposal, both in terms of their external and internal amenities. The further work undertaken by HA Acoustics for the appeal and submitted at Proofs Exchange has been reviewed by Mr Davis. They have not dealt with his concerns, as will be explored in evidence. In the assessment of the noise environment, the levels predicted to arise and the technical ability to achieve them is only one part of the picture. There is no single objective noise-based measure that defines significant observed adverse effect levels, nor one for lowest observed adverse effect levels, remembering that adverse effects on health and quality of life can be detected above lulls. There is a judgment to be applied in assessing the significance of the predicted levels and an assessment to be made of the real-world noise environment. Here, the 68 residential units will include family houses, where regular use of private gardens will be an essential part of everyday life. Half of the housing will be affordable, where future occupants will have less choice over their future housing. In addition to Mr Davis, Mrs Hutchinson addresses these matters. The proposal will not provide an acceptable level of amenity for future residents, contrary to the national policy objective of providing a high standard of amenity, promoting health and well-being. The proposal will not integrate effectively with the existing businesses of the Manor trading estate, and it's likely that those businesses will have unreasonable restrictions placed on them as a result of the development. As to parking provision, following the submission of a revised development master plan, that's the revision C plan, by Mr Ford at Proofs Exchange, demonstrating how parking spaces which meet Essex County Council's parking standards can be accommodated on site, the issue has narrowed. The effect of this for the appeal scheme will be explored in evidence, as will the extent to which the proposal adequately mitigates its impact on the existing parking provision within the adjoining Manor trading estate. Mrs Hutchinson considers the other claimed very special circumstances in her proof and undertakes the planning balance. The provision of market and affordable housing carry considerable weight in the planning balance, particularly given the Council's acknowledged long-term undersupply of housing and its decision not to adopt its draft local plan in June of 2022. The consideration given to the allocation of this site through the early stages of plan making, its proposed allocation as an employment site, and the rejection of that allocated employment site by the local plan examining inspector are part of the local plan history. They are no substitute for the full consideration of the merits of the current mixed-use appeal scheme at this appeal. The need for housing does not trump Greenbelt policy, especially given the in-principle harm to openness, and other harm identified here. The weight to be assigned to the other claimed very special circumstances will be explored in evidence. Finally, in its note of the 23rd of February of this year, that's core document K16, the Council has set out its position in relation to the restocking notice of the 13th of February, issued by the Forestry Commission and requiring restocking of the appeal site with 183 broadleaf trees. It is a material consideration of very significant weight for the determination of this appeal and has serious implications for the outline scheme as presented. The appellant's response, which is dated the 27th of February, so yesterday, does not change the Council's position. For the purposes of opening, I make some brief comments. Firstly, the Council's legal analysis of the position is not disputed by the appellants. The only legal route to challenge the restocking notice is through judicial review. That is, on a point of law, not the facts. And just pausing there, I see that points are made in Mr Ing's opening about material considerations, so I'll deal with those now that they've been raised, and I'll come to those in closing. Secondly, no judicial review has yet been actioned or issued. The letter sent to the Forestry Commission is sent by Mr Smith in person. It does not contain formulated legal grounds of challenge, nor does it constitute a pre-action letter. Judicial review proceedings must be issued promptly and in any event within 3 months of the decision taken. And just picking up the footnote on that, the test is promptness, and a claim will not necessarily be made promptly simply because it's been made within the 3-month period. The restocking notice remains valid and in force until overturned by a successful challenge in the High Court. Thirdly, apart from that, the appellants rely on the hope that the Forestry Commission will agree to replanting on only some of the locations and or in other locations. But the notice requires the 4 areas identified on the map to be evenly restocked with trees, including 50% oak trees. The appellants seek to revisit issues covered in the appeal against the original restocking notice. There is nothing to suggest that the Forestry Commission will accede to such requests. In the circumstances, it is highly unlikely it will. And fourthly, the plans submitted with the response will be considered and explored as necessary. Overall, the harm to the greenbelt, the harm to the openness, the harm caused by the resulting noise environment with its poor level of amenity for future residents, and likely impact on existing businesses on the Manor trading estate, and the harm caused by inadequate parking provision to mitigate its impact on existing parking provision are not justified by the proposal, and there are no very special circumstances which clearly outweigh the considerable harm which the appeal scheme will bring. So in due course, sir, we will be contending that the appeal should be dismissed.
Thank you for that. It's 10:50 now, so we're running a little bit ahead of schedule. Let's just take a break. I had allowed 15 minutes in the programme, but would 10 suffice, do you think?
Yeah.
Yeah? Okay, so we'll adjourn now for 10 minutes and come back at 11 o'clock. Thank you. It's time now to hear, in relation to noise, the council's case.
So would you just be willing to wait until my noise witness is back in the room? I think she might be in the toilet. It'd be good if she could just be here from the beginning.
While we're waiting, I observe that both the advocates are suffering to a greater or lesser extent from sniffles, presumably you've got a cold or anything. If that means that you get tired during the day and you want a break, don't hesitate to say so, because I certainly do not want either of you performing at less than your peak performance. So, okay. Are we ready now?
Yes, thank you.
Okay, thank you. Mr. Renatunga.
So I'm grateful. And Mr. Davis, can you hear me?
Yes.
I'm grateful. I'm going to introduce you by reference to your proof in a moment. Your proof, I think, has one appendix, and so I'm just checking whether you've got that. I'm grateful.
Yep.
And then, in addition to that, just in terms of papers, whether you've got it online or in hard copy, Mr. Davis, what we've got is Miss Nixon's proof and appendices, and also a rebuttal and appendices. Do you have access to those?
Yes, I do.
I'm grateful. And then we also have... so, sorry, I'm also just checking whether you've got access to those.
Yep, I've got the Miss Hutchinson's proof and rebuttal there, and you're going to refer to a few other documents as well.
I'm grateful. And then also, it's core document A 1.2.8, which is the HA Acoustics Facade Noise Exposure Assessment Report, version 2.
You give that reference
So
again?
that's core document A 1.2.8. We will be going to that. So it was submitted as part of the application. Mr. Davis, do you have that?
Yes, I've got access to that.
If it assists, so it's under that heading relevant submissions, the first section of core documents.
1.2.8. Probably
It should look like this.
Yeah. Do you know which memo that came with? Was that the first?
Sorry, it's in so if you've got the list of core documents.
Yes, I have, but they're arranged.
So under relevant submissions, if I can help, I think it starts with 1.1, which is the revised application form. And then if you go down, there's 1.2.8.
Yes, unfortunately, the way I've got them sent to me is in order of the emails. So, and there were two related to core documents A. So I'm obviously looking at the wrong one.
I don't know, sir, whether I can assist in that there is an appeals website which has got all the core documents on.
That may be quicker, but oh no, I've got it here. A1 2.8. Acoustics facade noise exposure assessment. Is that the one?
Version 2, yes.
version 2, yeah.
I'm grateful.
Yeah. Right, yes. Got
I'm
that up.
grateful. Thank you, sir. So, Mr. Davis, just to introduce you by reference to your proof, your name is Edward Davis, is that right?
That's correct, yes.
And you're a pollution planning consultant. And you, in terms of your qualifications, you have the Institute of Acoustics Diploma in Acoustics and a Noise Control and Certificate in Environmental Noise Measurement. Is that right?
That's correct.
And you hold a BSc Honours degree in Environmental Health. Is that right?
That's correct, yes.
I'm grateful. And in terms of your experience, you say you've been dealing with specialist noise and planning cases for local authorities such as Camden Council and the City of Westminster for over 30 years. Your main duties for Castle Point Borough Council are to assess environmental issues in relation to noise and vibration in planning applications and to give specialist acoustic advice to the authority's Environmental Health Department. Is that right?
That's correct, yes.
And you also, in additionally, provide private consultation services on acoustic matters and vibration on projects like HS2 and major infrastructure companies. Is that right?
Yes.
And you've prepared, as part of your work, acoustic assessments in support of planning applications, both for residential and commercial developments.
Yes.
You set out in your proof that you were instructed just before Christmas, 21st of December, is that right?
That's correct, yes.
And requested to represent the authority, and before accepting those instructions, you reviewed the application papers and paperwork and satisfied yourself you could defend them.
Yes, I was sent the documents and reviewed those, yes.
I'm grateful. And then with regards to reason for refusal 4, so that's the one that was talking about the impact of the acoustic barrier on the Manor trading estate.
Yeah.
That's something that you did not feel you could defend, is that right?
That's correct, yes.
Which is why the council withdrew that reason for refusal.
Yes.
I'm grateful. And so in terms of your evidence to this inquiry, you're dealing with reasons for refusal 2 and 3, which are taken together, is that right?
Yes.
I'm grateful. Now, so subject to any comments you have, I'm going to take the proof as read, so that we don't need to read out. I'm grateful, or go through each point. We're just going to cover some of the key points, okay? So firstly, just looking at paragraph 1.7 of your proof, yeah?
Yes.
You conducted a site view, yeah?
I did, yes.
In January of this year. Can you help us, please? Give us an overview of the existing noise environment from what you experienced, please.
Yes, well, immediately entering the site, you notice the operations of the scrapyard itself. There's a large metal crusher with an attached compressor to it. In view, there were multiple excavators or grabbers which were picking up steel and moving it around the site. There was another excavator that was dropping steel inside the crusher itself. Those noises were your immediate effect as soon as you entered the site. Additionally, there's other noise sources. There's a car breakers there and other units that were actually working externally. So that there were multiple noise sources audible once entering that site.
Okay, and so you've mentioned there the scrapyard, and by that you mean Benfleet scrap, is that right?
Benfleet scrap, yes.
You've set out the noise sources from that and the types of noise.
Yes.
And you've also then mentioned, for example, car breakers. Just help us with that. Is that on the Manor trading estate?
That's actually on the Manor trading estate, yes.
Yeah. And in terms of those other types of sources, is it just the car breakers, or is there anything else you want to mention in relation to that?
Well, as I said, that there were multiple units that were there. You've got car repairs, breakers, and other units that were actually working outside of the units themselves.
Yeah. And just to look at a little bit more detail on that, in terms of the noise sources, you've mentioned the metal crusher,
yes,
and the compressor. I think you said multiple excavators. How many did you see?
There were at least 4 on my site visit.
And in terms of the noises that you hear, so I think you've mentioned the excavators dropping metal or moving metal
Yes.
onto items. What about the crusher when it's in operation? What do you get from that?
Well, you initially you get the excavator dropping metal inside the crusher.
Yeah.
Then you've got the noise of the compression, which then motors the crusher to crush the metal inside that compactor.
So there's the sound of the crushing.
Yes.
Yeah. And what about the engine or the...
Well, you've got the engine noise of the excavators moving around the site. Additionally to that, the ones that were in operation, you can hear those shifting metal around the site as well.
And what about the crusher itself when it's on and off? What do you hear?
Well, the first thing you notice is the metal dropping in it. You then have a very loud noise from the compressor that's operating the crusher itself. And that noise is the more dominant noise of Benfleet scrap.
And to what extent do you hear a hum from the compressor?
Well, that compressor is that dominant hum, which is, I was on site for well over an hour. Wherever you stood on that site, you can hear the noise from that unit.
Okay, and you've mentioned the sounds of effectively metal on metal, is that right?
Yes, that's correct.
Whether it's being dropped onto the, put onto the compressor or when the metal's being crushed, is that right?
That's correct, yes.
All right. We'll come back to those characteristics later. And then you touched on this, but I just want to be clear. All of those elements that you've mentioned, so the excavators moving around, moving metal around, the dropping of metal onto the compressor,
Yes.
the crushing of the compressor, and the sound of the compressor when in operation.
Yeah.
To what extent can you hear them across the appeal site? The whole of it, half of it, part of it? What?
All of it, from north to the south, wherever you went, while the crusher itself was in operation, that noise was clearly audible above anything else you heard.
Yeah. And in terms of that sound of metal upon metal, do you want to just help us with how would you characterise it? At what level? What sort of, put it in sort of real world terms?
Well, if you imagine while it's not operating, I won't say it's relatively quiet, but you hear the drone of engines and metal scraping. Then suddenly you've just got a very loud sound whirring up from the compressor itself.
Yeah.
And then on top of that, you then have the metal dropping in at the same time. So it is so noticeable from when it's on, from when it's off.
So noticeable?
Yes.
Across the whole appeal site or part of it?
Across the whole site.
All right. And from there, please, can we go to the core document, which is the HA Acoustics version 2 document, please, which is 1.2.8, which we were just talking about.
Yep.
And just to get our bearings on this, this was submitted, it's dated April 2022, is that right?
Yes.
And it was submitted as part of the planning application, is that right?
That's correct, yes.
Yeah. And in that, if we can go, please, to page 38. Now, so I think you're online for this, aren't you? So you're on your computer. I think it's page 38 of the PDF.
Okay, well, I'll find it. This is a plan with noise contours.
Correct, should look like that.
Yeah, got it.
I'm grateful. And there we can see, it's a noise map, daytime existing site, yes?
Yes.
And it's got the colour contours that you'll be well familiar with,
Indeed,
Mr. Davis.
yes.
And we can see the Benfleet scrap site with the sort of dark blue colouring, and then we can see the appeal site with sort of radiating red and orange. That's what I'm saying about it. But you help us, please. You've described what you experience when you visit the appeal site. This is the colour-coded noise contour map. Do you want to just help us with that?
Well, you can see from the colour coding in terms of noise propagation into the site, the closer you are to Benfleet scrap, obviously the noise levels are higher. Those are being predicted by the darker reds.
Yep.
But as you move out, yes, the noise does dissipate, but it's still in the orange.
Yeah. So if we can see the woodland, you see the woodland.
Yes.
On the eastern end of that picture. Yes. And that's the edge of the appeal site. Is that right?
That is, yes.
And we can see it's still in the orange broadly. Is that right?
Yes.
For most of that area. What kind of levels are we talking about?
Well, if you're looking at the extent of the site, you are looking at levels according to this noise map between 68 to 71 decibels.
And then we've got red. Just help us with kind of levels for red, which is nearer to Benfleet scrap.
Well, the nearest ones, you're looking levels between 83 to 86 decibels.
Thank you. And how does that fit with your assessment when you did your site visit?
I think that this predicts the noise quite well. It does show that the noise is audible to the full extent of the site.
Yeah, as existing.
As existing, yes.
I'm grateful. So that's helpful. And then next I want to just cover this, please, because those are existing levels.
Yes.
Okay. But there's a question here about how you judge levels, am I right? And the significance of the levels assessed. Yes. And for that, you deal with that in your proof. So we will come back to V2. But I just want to look at your proof on this, please. On relevant national policy guidance,
Yes.
That's from page 3 and following of your proof. I'm going to take that as read, but I just want to pick out a couple of points. The NPSE, okay, so page 4.
Yes.
You talk about the noise policy statement for England, yes, the NPSE, and you set out there what it says, or sort of summary of sort of points it makes.
Indeed,
And
yes.
it refers to Knolls, Lulls and Souls, I think is what we're going to be referring to them as, which is on page 5, lowest observed adverse effect levels and significant observed adverse effect levels. And then you say that it's not currently possible to have a single objective-based measure that defines souls. Yes, you say that on page 5. Just help us with that.
Yes. Well, with noise, you can't say it's one particular level that causes a particular health effect. You've got to have a range from lower to higher to say this range of noise will give a particular noise effect. And there's a range of that for lulls, souls and knolls. Yeah.
And in terms of sort of levels, do they apply equally from all noise sources in all situations?
Yes.
Or do you have to exercise judgment in how you apply them?
Well, it is a judgment because it's not a prescribed method.
Yeah. So there's no single objective-based measure for a soul.
That's correct, yes.
And when you come to consider that, you have to look at the circumstances.
Yeah, you look at it. You look at it in the round as to the noise sources and the type of noise that's actually there.
Thank you. And then, still on sort of guidance documents, in your proof, so looking at internal levels, all right, internal levels. So that's inside proposed residential development. If you look at page 6 of your proof, page 6, there you refer to BS 8233 of 2014 at the bottom of that page.
Yes.
And that is, just help us with, first time we've seen it, what is that?
Yes, well, 8233 is guidance for internal sound insulation level, which helps acoustic consultants to design facades to achieve internal and external noise levels.
Yeah, and you refer at the bottom of page 6, and onto the top of the next page to levels for internal ambient noise, yeah?
Yes,
Which derive from 8233, is that right?
that's correct, yes.
And we can see there, resting for living rooms 35 dB, LAEQ 16 hour period, dining is 40, sleeping is 35, yeah?
Yes.
And those are levels from BS 8233. Just looking at page 7, please, page 7, you there talk about what Castle Point Environmental Health use.
Yes.
Yeah. For internal levels. So the table that we've got on at section 7 on page 7. Are you with me, sir?
Yep.
I'm grateful. That has, I can see, the same levels in the 7 to 11, 7 to 2300, 35, 40 and 35. Is that
Yes,
right?
that's correct.
So
Yes.
just give us the context, please. That's what Castle Point uses. Where does it derive from and how's
Well,
it defined?
those levels are derived from BS 8233.
Okay. And you've said that you're a pollution consultant for Castle Point, is that right?
Yes, I was brought in a year or so ago in that capacity.
Okay. And so when you're assessing internal ambient levels for planning applications involving, for example, residential development.
This is the criteria that is currently used and has been used for the last 12 months.
Okay. Thank you. And I think you said elsewhere you're the external consultant that Castle Point use.
Yeah,
one of them. Yeah.
I've been brought in to review all of the incoming planning applications in terms of noise and other pollution effects.
I'm grateful. All right. Now that's internal guideline values.
Yes.
All right. Just switch to external. All right. And for this, I need to go to a core document on this, please, which is BS 8233 itself. So if we can just go down to bear with me one moment. Yeah, it's core document C. Core document C. And then it's C8. C8 is 8233.
Yep.
Is that right?
That's
I'm grateful. And in that, if we go to page 25, please. Page 25.
Yep.
Now, that is page 31 in the PDF, page 25 on the actual document.
Starts note 5, is that right?
Correct. Thank you, sir. And then just under that, we can see living accommodation. Yes, Mr. Davis?
Yes.
And regulatory framework, and then there's a heading.
Yep.
Yes, are you with me? And 7.7.3.2
Yes.
is the design criteria for external noise, yes?
Yes, it is.
And there's reference to this in the proofs, but I wanted to just go to the original document. So we're looking at external levels, yes, in
Yes.
published guidance, and this is design criteria for external noise, and we can see what it says. For traditional external areas that are used for amenity space such as gardens and patios, it's desirable that the external noise level does not exceed 50 with an upper guideline value of 55, yeah?
Yes.
Which would be acceptable in noisier environments. So just help me with those figures first. You can see the whole paragraph in a minute, but
Yes.
50 and 55. So it does not exceed 50 with an upper guideline value of 55. How do you read those? What do you take that to say?
Well, for me, I look at the 50 dB as the standard level because these two levels run concurrently with the World Health Organization guidelines that sets health effects against these levels. Mm-hmm. Obviously, the higher level of 55, you'll have a higher degree of health effect. 8233 says or intimates if the area is generally city centre, urban or adjoining the strategic transport network, then you can consider the upper level of 55.
Yeah. Before we get to that, in terms of so 55, you've said there's a higher degree of likely effect on health at 55.
Yes.
Does that mean does that mean there's no effect?
No, according to the World Health Organization, that there is still possibility of health effects even at 50 dB.
Yeah. And in terms of sort of levels of annoyance, what would you experience at 50?
Well, you'll still have to possibly externally raise voices.
Yeah. So what degree of annoyance would you experience with around 50?
Well, if you've got young children outside, then obviously you're having to raise your voice over the noise you're experiencing.
Yeah. What does that mean?
Well, for me,
level?
I wouldn't see that as acceptable, that you're having to raise your voice above normal to speak within the confines of your own abode.
Yeah. All right. Now then, sticking with this paragraph, it goes on to say 55, which would be acceptable in noisier environments, and then it goes on to say, however, it's also recognised that these guideline values are not achievable in all circumstances where development might be desirable in higher noise areas such as city centres or urban areas adjoining the strategic transport network. A compromise can be reached, right? And it goes on to say development should be designed to achieve the lowest practical levels in external amenity uses, but should not be prohibited. So let's just have a look at that. In terms of this area, the area of the appeal site and its surroundings, what do you say as to whether it's a higher noise area such as a city centre or an urban area adjoining a strategic transport network?
Well, in my opinion, I definitely wouldn't say it classes as a city centre or urban, but that particular area, up to myself, I would say is more semi-rural, given the large amounts of open space around that site. In terms of adjacent to a strategic transport network, you're looking at the nearest strategic transport network of over a kilometre away, so I wouldn't say that site is adjacent to it.
So it's I think I know the answer to this, but would you describe it as a higher noise area as a result?
No, it's only a high noise area because of the commercial use from.
And it says at the end, you should be looking at, in those higher noise areas, you should be looking to achieve the lowest practical levels because of this compromise, right? It's desirable.
Yeah.
But should not be prohibited. I mean, what does that mean in real terms? Is that something that, what do you say is your judgment in relation to that?
Well, my judgment, especially within this case, yes, if it's a higher noise level without affecting the current noise environment, then you would possibly consider it. If it is next to a busy road, let's say, you're not going to try and limit the noise from the busy road, but you're dealing with commercial entities here.
Okay, thank you. So we can put 8233 down. Anything else you want to say about that paragraph?
No.
No. So we'll go to, can we go back to the V2 report, the HA Acoustics report version 2, please? So we've looked at the existing noise environment. We've looked at guideline values, yeah?
Yep.
Internal and external. Can we next go to, so we were on page 38, so which was the colour noise contours, yeah?
Sorry.
And if we can go forward, please, to page 42. Page 42, and just have a look at that first. And just to get our bearings, that is the facade level map revised layout, is that right?
Yes.
And that's with the acoustic barrier in place and the scheme in place, is that right? And the levels that would be predicted.
That is my understanding of it, yes.
Yeah. And if we just turn back one page to page 41. That's the colour-coded noise contour map as predicted with the acoustic barrier and scheme in place. Is that right?
That's correct, yes.
So you should have that.
Just bear with me, Rent. I've lost my page. Sorry, give me the core document reference again, if you wouldn't mind.
So this is this was core document A 1.2.8.
Made the same mistake of looking at the wrong memo. Sorry, I can't find it. Have we got a hard copy, by any chance?
Should we have a look?
I had it up earlier, but I've lost it now.
I don't know, sir, whether I can just walk you through to the council's website, which has all of them on.
I think I've got the same problem, which is quite slow to find them. I mean, I've got them all here, and I've made a reference, so I can...
I don't know if it would... I can do it quite quickly on my laptop. I don't know if I can just say, if you Google Castle Point Borough Council, and then within the council's website, Manor Trading Estate Appeal,
Yeah.
you do get all the four documents. I think that's right.
Yeah.
Okay, let's try that.
Yeah, there's a dedicated page, isn't there, with everything.
I think the benefit of that is through the inquiry, it will be much quicker.
Mm-hmm.
So it's probably worth spending the time if we can.
Yeah, okay, let's... So, and on their website,
If you search in the top bar,
yeah,
Manor Trading Estate Appeal. There should be only one result that comes up,
yeah.
and click on that one.
Yeah, core document list.
And then, so in that one, just a minute, if you look in the top section, that's A submitted application relevant submissions. So I don't know if I can. If I
Oh,
show
sorry,
you that
yeah,
right
yeah.
or-
Got it, sorry. Yes. Core document in it, and this is,
1A 1.2.8.
yeah, there we go. doesn't open it up, it just gives me a list of the documents, unfortunately.
I don't know, so if I can just show you just on this, if it's helpful. So
Yeah.
I've got this page here. Do you have that page?
Well, I thought I had, but obviously not. Let's go back and try again. So, I've got that page.
And if you come down, you'll see relevant submissions here.
Ah, yeah.
And under that, you've got 1 and all the numbers. And if you go down to 1.2.8,
Yes, yeah, got it.
you click on that.
Yeah, it's coming up now. Okay. And we were on page 40.
The way that works, though, is once you're in the document, to come back out, you go backwards to
Yeah.
the main page and you have to go in again.
Yes.
Whilst that's been done, we have fished out the document itself if you want a hard copy. Just
That's even better, but yeah, I'll because this is scrolling through from page to page is not quick. You were on page 42 first, your first question, and then you went to 41.
Yes.
So 42 is 38. It's also very annoying that PDFs and the actual document have different.
Yes, I believe it's 42 of the PDF.
Yes.
42 of the PDF is the estate layout.
Facade level map, revised layout. Top
Yeah.
right hand corner. Looks like this.
Yep.
Yep, I'm grateful.
Level map revised layout. Yep.
All right, so that is, as we were just saying, Mr. Davis, is that right? The predicted noise environment with the acoustic barrier and the scheme in place,
Yes.
yeah?
Yes.
With points and levels that have been assessed, yes?
Yes, they've plotted facade levels.
I'm grateful. And if we turn back one page, that's what we were doing to 41, we can see the noise contour colour map for the predicted with the acoustic barrier and scheme in place, yes?
Yes.
Sorry, Mr. Anatonga, can you... I'm sorry to...
So page 41 should look like this.
Yes. I didn't understand your question about page 42, I'm afraid.
42, if we look on the right-hand side, so you should have a plan that looks like this.
Yep, and it's got various numbers on it, some in red,
Yeah,
some in
and under
some
where it
yellow
says
boxes.
AD961-1, and it's got the address, Land East of Manor Trading Estate. Top right-hand corner of page
Yes,
42.
8961.1, yep,
Yeah, and then underneath that it says facade level map, revised layout.
yes.
I'm grateful.
And your question was, what does this show?
Yes.
And I didn't understand the answer in relation to that.
Do you want to give the answer again? What does it show?
Are we looking at 41?
No, 42 now.
42.
Yep.
42 shows the facade levels calculated.
How does it do that? What am I looking at to see that?
So we can take the inspector through that, I think, helpfully. If we just do it this way, please. We're on page 42. You can see plotted in grey hatching, is that right, on the appeal site, numbers. We've got sort of 5 and 12, if I look at this way. 5 and 12 here.
Yeah, in red.
In red, yeah?
Yeah.
So those are what, please, Mr. Davis?
I'm taking those numbers in red to be the proposed residential buildings.
Yeah. So that identifies those two grey areas in hatched, yeah?
Yes.
And then we've also got, the other ones I'm looking at is 14 and 15, which are here. So to the north of the site.
North.
Yeah. And you've got a sort of diagonal grey hatched area. Is that right? And that's another residential facade. Is that right?
Yeah, that's correct, yes.
Yeah. So, and then the red numbers just identify the actual buildings, all right?
Yes.
But if we look at, if we can, the smaller numbers in sort of yellow circles, yes? So numbers, if I look here, above the 5, yeah, on the facade nearest to Benfleet scrap.
Yes,
Yeah.
building number 5.
Building number 5.
Yes.
Are you with me, sir?
Yeah, I'm with you with that, yeah.
What's the number we've got in that?
Well, the facade closest to Benfleet scrap, you've got numbers in terms of building number 5, you've got 62 dB,
Yep.
building number 12.
So hold on, just take it in stages. Number 5 is 62 at that facade. Yeah?
Yes,
So that's 62 decibels.
decibels.
LEQ 16 hour.
16 hours.
Yeah. Then if we go up to building 12, or that one that's sort of all the way along above the road, what's the level there, please?
You've got a level of 61 decibels.
Yeah. Are you with me, sir?
Thank you. That's very helpful. I
Okay.
saw that drawing when I was preparing for this event, and I didn't understand it, and I hoped you would be able to talk us through it. So thank you for doing so.
Okay, so that's those two, which are, I think you said, the nearest residential facades to Benfleet Scap.
Yes,
Yeah. And then we were looking at, the other one identified was 13 and 14, so it's these, yes?
to the north, yes.
These ones, sir.
Yeah.
Again, just help us with the figures we've got at those facades,
The
please.
figures I've identified, that those sources are 60 and 59.
So we've got, I can see 60 next to the number 13.
And 59 next to the number 14.
Yeah. Okay, so we can see that these are the predicted levels with the acoustic barrier in place and the scheme in place.
Yes.
Yeah. And we can see the figures that they have at the nearest facades to Benfleet Scrap, yes?
That's
Residential facades.
Yes.
Yeah. Now, you've helped us with levels internally
Yeah.
and externally, all right? Guideline levels. What do those sorts of levels mean here? You've referred to 60, 61, 59 and 60. What does that mean?
Well, it is generally accepted. If you've got a partially open window, you can reduce the level anything between 10 and 15 dB. So if you're looking at 61, for instance, then you're looking at a facade level then of 51.
Yeah. So I think it says no more than 10 to 15. Is that right?
That's correct, yes.
Yeah. And so at the facade, you've got those levels.
Those levels, yeah.
But if you had windows which open,
then
you'd have a reduction of no more than
10 to 15 decibels.
grateful.
Yes.
All right. And so what do you say that means for the internal environment? So even allowing for open middle windows, let's just say.
With these figures, even allowing for your reduction, you've still got levels in excess of, if you're looking at resting during the day, you've got 35 dB LAEQ 16 hours. So
35 is what you should be
yes,
getting.
yes.
Yeah. And so are we in excess of that or not?
Well, yeah, even with your partially open window, with these predicted levels.
Yeah. And we know, it's not in dispute, that this document, so the report submitted as part of the application, what did it propose in terms of mechanical ventilation?
Well, what it proposes is that mechanical ventilation is required for the complete site, and that is, i.e., windows closed with mechanical ventilation.
Yeah. And you can help me with the lay terms. Mechanical ventilation, what is that?
In want of a better word, you can just say air conditioning.
Yeah.
Yeah.
So that is specified for the whole of the development in this report. So effectively, what does that mean? To achieve satisfactory internal living the satisfactory internal living environment.
Well, throughout the year, if you want satisfactory living conditions in terms of a noise environment, you've got to keep your windows closed.
Okay, and we all know what the weather's like and when there's warmer months.
Yeah.
And you've mentioned families with children, for example. What do you say about the acceptability of that as an outcome?
I think generally, if you have families, I think it's not reasonable. I know you can have your windows open at any time of year, but generally during the summer, if you have young children, right, inside, I think is not acceptable that you've got to have the windows closed. It's quite reasonable that somebody wants to either partially or fully open their windows.
Yeah. All right, so that's internal levels.
Yes.
Yeah, from this plan. Just switch to external. All right, so if again, we've got to do a little bit of magnifying glass work here as well, I think. But if we've got the same, if we just look at the same two facades that we were looking at, 5 and 12,
Yes.
yeah? But look on the other side of the building, all right? So where you've got the number 5, just above that to the right, what's that figure there?
You've got a facade level of 57.
Yeah. And then at number 12, just help me with that figure.
You've also got 57.
Okay, so this is in a situation where, let's just say there's external amenity areas on the other side of the building.
Yes.
Is that right? It just help me, is that right? Is that a helpful way of doing it? That's the sort of level that you'd be looking at, or not?
As I'm assessing a planning application, that's how I would review it, because that's how it's indicated on the plan.
Okay, and so what do you say about external levels of 57 on this site? Now, you talked about the guidelines in 50 and 55, but just help me with that.
Well, clearly 57 is above the upper limit, so therefore immediately not acceptable.
I think you said at 50 you would be likely to have to raise your voice.
Yes.
Yeah, so if you're talking about 57, just help me with the degree of annoyance or moderate annoyance, or what you would say in terms of what you would experience and what you need to do.
You'll definitely be more than annoyed with having to put up with a constant level, and that's what these levels are. They're a level over your full day.
Yeah.
Where it is noisy.
Okay.
So you will be, in terms of health effects, having to raise voice, the stress that generally causes on people.
Yeah. And then we know that there are public open spaces provided on the site. Is that right?
Yes.
And one of those is towards the eastern, southeastern end. Is that right?
That's correct. Yes.
If we're looking at the building numbers, it's near number 1. Is
number
that right?
1? Yes.
And in fact drops down south of that. Is that right?
Yes.
So here. And again, doing the best we can on these figures, just help me with what sort of figures we're looking at. I can see next to number 1 is 51.
51.
Yeah.
You've got number 9, also 51.
Yeah. But talking about the public open space, that's down by building number 1, isn't it?
Yes.
And you can see levels around 51 down there. Is that right?
Yes, that's correct.
Right. Again, that's the just talk us through that. You know, you're in your garden, and your level at the nearest residential facade is around 57, and so you go to the public open space and the level is at 51.
You're still affected by noise from the trading estate, even in that particular area.
And if it's at 51, I think you were saying 50 or thereabouts, you might have to raise your voice. Is
Yes.
that right?
Yeah.
Yeah. All right. Overall, what does that mean for the noise, the predicted noise environment and levels of amenity, internal and external, as shown on this plan?
Well, in terms of shown from this plan, even with the 10-15 dB reduction, you will be affected by noise internally.
Yeah.
Externally, you've got no escape from excessive noise from the trading estate.
Thank you. What do you say? So this is version 2 of an HA acoustics report, which was produced in support of the planning application. Is that right?
That's my understanding, yes.
Yeah. What do you say about its status and the ability to use it? What's your take on it?
Well, in terms of following guidance, the measurement procedures are fine.
Yeah, so in terms of methodology, do you
the
take any issue with it?
methodology calculations, I've not and didn't raise any issues with.
Yeah.
I raised issues with the interpretation in terms of, because of the elevated levels, it's an urban area, so therefore the upper limits could be considered.
So it's the judgments on
Yes.
the levels that you take issue with.
Indeed,
As
yes.
well as, I think, in your preview, you talk about what's assessed. Is that right?
Yes.
Yeah. All right. Thank you. From there, can we go to Miss Nixon's evidence, please? And for this, if we can go to her proof of evidence. I'm grateful. And just to pick up on that point, again, in terms of methodology, so Miss Nixon's come into it and done her own assessment, yeah?
Yes.
And in terms of methodology and technical basis for the survey work, any comments on that?
In terms of methodology, again, measurement procedures have been followed, but I'd have to say it to a point.
Yeah, we'll come on to that. But again, in terms of the judgments formed...
My judgments in terms of both reports, in terms of how they've judged the noise and assessed the noise, is the same. I'll take issue with
You disagree with both?
I disagree with both.
Yeah. Okay. So just a couple of points on this, please. Firstly, if we can look at paragraph 3.5.
That's page number...
Page 15, paragraph 3.5. So this is to do with attended noise surveys, yeah?
Yeah.
And we can see that surveys were undertaken on Wednesday the 11th of January and Tuesday the 17th of January.
Yes.
Yeah. And it's not in dispute. I believe the 11th of January data received was disregarded because of the wind conditions being unhelpful for assessing noise on that day. Is that right?
That's correct, yes.
So it's the 17th, Tuesday the 17th of January figures that are relied upon.
Yes.
Yeah? And in relation to that, if we go to the next page, page 16, paragraph 3.10, it says, whilst undertaking the manual measurements on the second visit, so that's the 17th of January one we've looked at, the baler, now part of this terminology, the baler is, I think, what you've referred to as
the crusher.
Metal crusher,
Yeah.
compressor, on site, was operational for the entire manual survey. And then it says this, at time of survey, so this is impressions formed having gone to the site, attended survey, isn't it?
Attended, yes.
At time of survey, the baler was therefore the dominant noise source.
Yes.
Yeah? Road traffic, aircraft and other noise from Benfleet scrap with lorries tipping or tracked grab excavators were audible. What do you say about that comment? Obviously, were you there on the 17th of January?
I wasn't there on the 17th.
But compared with your site visit, to what extent were road traffic, aircraft, and those sorts of road traffic and aircraft? To what extent were they audible?
While I was on site, and I was on site for well over an hour, the baler, yes, is the dominant source, but you could not hear road traffic or aircraft noise above the noise of that baler.
Okay. And if we go forward, please, to pages 22 to 24. Here we have, this is in the section noise survey results, is that right?
And this is page 22.
Yeah. So just to get our bearings, page 21 is the noise survey results. Yeah.
Yeah.
And then turn over to page 22, we've got a heading subjective comments.
Yes.
And then we've got a table which goes over 3 pages. Yeah.
Yes.
Looking at monitoring positions. And you can see on the left-hand column, summary of dominant noise sources. And it's got 11th of January, And then on page 23, it's got 17th of January. Yeah?
Yeah.
And you can see reference to various positions: school children, road sweepers, children playing at the nearest school, aircraft. Those references, just help me again. You were not there on that day.
I wasn't there on that day, no.
All those days, 11th or 17th, but you were there, I think, a few days later.
A few days later.
Yeah. Just help me with this. Was the school open when you were there?
Yes, the school was fully open and fully operating.
Yeah. And to what extent would you describe road traffic, children playing at the nearest school, road sweepers, that sort of thing, aircraft? To what extent would you describe those as dominant noise sources?
Well, none of them. While Benfleet scrap is actually operating and the crusher stroke baler is operating, that is all you can hear, even at the furthest extent of that site.
Thank you. Now, if we just turn forward, please, to page 27. Page 27. There's a section there entitled Characteristic Penalties. Yeah?
Yes.
And it says the following penalty additions have been added to the operation of the scrapyard. All right? So just help me with getting our bearings in why that's done. What are characteristic penalties? What are they applied under? What's the guidance they're applied under, and why?
These penalties are under BS 4142 in terms of assessing the effects of commercial noise on noise-sensitive receptors.
So BS 4142 is about assessing the effects of industrial noise.
Industrial noise on
yeah.
noise-sensitive receptors.
And as part of that assessment, what does characteristic penalties do?
Well, depending on the makeup of noise, you add a subjective penalty to each element of noise you think is there. From
subjective penalty?
Yes.
In the real world?
Crashes, bangs, hums,
yeah,
and how audible a particular noise is.
So it's about the character of that
the
noise.
Character makeup of the physical noise itself.
Yeah. Okay, and 4142 has certain things that you take into account. We can see the table, yeah?
Yes.
And we can see intermittency, impulsivity, and tonality.
Yes.
Yeah? And if we just take those in turn, please. On the first one, yeah, intermittency. So no penalty has been added by Miss Nixon to Benfleet scrap operation for intermittency. And we can see from the note, the baler was running continuously in the 1 hour period within the acoustic calculations.
Yeah.
Yeah. And you can see in the text above, the same point is made. Yeah, 4.16.1.
Yes.
Yeah. In your view, was it, when you visited, you were there for more than an hour, is that right?
Well over an hour,
yeah.
yes.
Was it intermittent or not?
Yeah, there were times it was running, and then it was off for a few minutes, and then it was back crashing again.
Yeah.
And it's on and off.
Yeah.
Yeah.
And so for intermittency, so it's a subjective assessment, of course.
Yes.
But what would you assign for intermittency?
I would say at least a plus 2 dB for that, if not more.
So I think the guidance says you do a plus 3. Is that right?
Yes, yeah.
And that's 4142, is that
41.
right? You can go to it if you need to, but
yeah.
if it's plus 3, is that right?
Yeah, for BS 4142.
So that's intermittency. Then impulsivity. Okay, so you would add a plus 3 for that where she has 0. Impulsivity, so there's a plus 6 decibel level for that. Just firstly, to help us in plain terms, what's impulsivity about?
What 4142 says a correction up to 9 dB can be applied for a sound that is slightly impulsive.
So in this case, what's the impulsive sound?
The sound of the crusher.
Yeah, the loud bang, for
yes.
want of better words, yes. And for impulsivity, there's a plus 6 applied.
Yeah.
What do you say about that?
And that the +6 is where it is clearly perceptible.
Yeah. So do you agree, disagree, add
Oh,
more?
no, I agree with that, yes.
Yeah. So you're at +6 for that, you're in agreement.
Yes.
And then the third aspect is tonality, okay? And just on this one, we can see a +2 has been applied for
Yes.
tonality. And the text above says this: a penalty has been applied for tonality as a slight tonal hum could be heard from the noise sources. The tonality was only just perceptible. So a +2 dB penalty has been, I think that should say, incorporated. What's your comment in relation to that?
I wouldn't agree with that. While I was on site, that noise was way more than just perceptible. It was clearly audible. So I would have added a greater penalty to tonality.
Okay, so Miss Nixon's at +2. What do you put it at?
I would have a conservative estimate of at least +4.
At least +4.
Yes.
Okay. And just whilst we're on that, you said I think it's clearly audible. Yes.
Yes.
Can we just look at the appellant's opening, please?
Sorry, listen.
So if I read it to you, because I think there are only 2 copies handed out.
Yeah.
But paragraph 16, the appeal site is located immediately adjacent to a metal recycling facility operated by Benfleet Scrap. Noise from the scrapyard is clearly audible on site during its hours of operation.
Right.
Is that consistent or not consistent?
That's
with your view?
consistent in terms of it's clearly audible.
Okay, so looking at the assessment that we have for characteristic penalties by Miss Nixon, she puts it, I think, at +8. So what she does is she adds the 6 and the 2.
Yes.
If we were looking at your assessment, you've got a +3 for intermittency,
Yeah.
a 6 for impulsivity,
Yes.
agreeing, and on tonality you're at least +4.
+4. Yes.
Okay, so we add another 5,
5, which will give
to
you
the 8. So
+13.
So you would be at +13, yeah, for characteristic penalties.
Yes.
Yeah, and it's appropriate to add them in these circumstances. I think there's circumstances where you might not, but
Yeah.
you would add them.
Yeah.
here.
Given the characteristic and operation of Benfleet Scrap, you just have to consider the noise makeup that's being emitted from that site.
Yeah. All right. Thank you for that. So that's where there's a difference on those subjective aspects. Now, if we go, please, to Miss Nixon's appendices. So if we can go, please, to Appendix D7. So that is page 16 of the PDF.
Yep.
And it's D7.
Appendix D7, yes. Thank you.
Yep.
And we should have there points map proposed mixed use scheme predicted noise climate incorporating an 8 dB penalty. Is that right?
That's correct, yes.
So this is the points map with the acoustic barrier in place and the appeal scheme in place. Is that right?
That's my understanding, yes.
And also incorporating the 8 dB penalty, which Miss Nixon applies. Obviously, you would put it higher.
Yes.
Yeah. So, firstly, just looking at that, just looking at Benfleet Scrap itself, all right, the red asterisks, yeah?
Yes.
They're source, they're crushers and grabbers, yeah? That's
Yes.
what's identified. And we
Yes.
can see the crusher in the top northeast corner.
Yes.
Yeah. And then there's 3 grabbers. What do you say about that, firstly?
My understanding and what I viewed on site, there's actually 4 excavators and grabbers.
Yeah.
Obviously, Miss Nixon has only modelled 3.
Yeah.
It's also my understanding that there is currently being built an aluminium shredder compactor.
Aluminium shredder compactor.
Yes, which is similar to the metal crusher, and that's situated more to the south of the extremities of Benfleet Scrap.
Yeah. And in terms of its operation, how do you understand that that's going to operate?
That's going to operate, or that is authorised to operate the full opening hours of Benfleet scrap.
Yeah, but in terms of the metal crusher,
Well,
firstly, you were talking about material being placed on a conveyor belt, being compressed.
You will have the similar operations as the crusher. You'll have the excavator picking up aluminium, dropping it onto a conveyor belt. That conveyor belt then moving to one unit that shreds it, then another conveyor belt that moves it to the compactor, and then you're having that noise of the compactor compressing it and spewing it out the other end.
And to your understanding, is that something that's done openly or housed?
It's a large open unit.
Yeah. Is that operational now? Do you know?
No, it's currently being built. So the majority, in terms of a structure, I understand from our planners, is currently there and visible. So
okay, so that can be seen on the site visit,
yes,
I assume?
Yes.
Potentially. All right, so that's in terms of what's assessed. And then in terms of the levels, including the characteristic penalty, so applying the 8 dB penalty that Ms Nixon does, again, so looking at it on its face, that's not allowing for your +5, all right?
Yes.
If we just do the same process, please, on the 2 residential facades here and here, what we've got is a noise receptor point, which is in green, which is number 3. Is that right?
That's correct, yes.
And next to it, we've got a box with 1 and 2 in figures 60 and 59. Just help us with that.
Well, my understanding of those 2 figures, those again are the calculated facade levels.
Yeah, with the acoustic barrier
with the acoustic barrier in place.
All right.
Could you ask him to elaborate on that? Because I don't understand why there are 4 boxes there. What does each of the 4 boxes mean?
So what does the 1 and 2... So 60 and 59, what do you understand those to be?
I understand those to be the facade levels, the 1 and 2s.
Hold on, so that's the decibel level.
The decibel levels.
AEQ,
yes.
Yeah. Predicted as at the facade level.
At the facade of that building.
What's the 1 and 2?
The one and 2 would be something I would have to ask Miss Nixon what those actual numbers predict.
Okay. But they're not, it relates to the noise receptor location number 3, is that right? Yeah, okay. So we can have that clarified later. And then in relation to number 5, and that receiver at building, do you see that one? That's the one we were looking at before in that location?
Yes, yes.
What have we got for figures up there?
You've got 48 or 58 for both 1 and 2.
Thank you. That's with the characteristic penalty added, all right? What do you say, again, just going through the same process, internal levels?
Well, again, with internal levels, your partially open window, your -10 dB from there, you've got an internal level there of, if you're looking at building 3, 50, and 49.
Yep. What do you say about those levels?
Well, at the end, those levels, the sound of Benfleet scrap will be audible within those properties with the window open.
To what extent is it on the threshold of acceptability, or whereabouts is it? How would you describe it?
I'd say that they're at the threshold of acceptability with the 8 dB penalty.
Yeah. What if you add the extra 5 that you do? If you add 13, what does that
then
mean?
The levels then would be unacceptable if you added the +13.
Thank you. And then externally, again, if we look at the receptors that we've got, on the other side of those same buildings, we can see, for example, 58 and 57.
Yes.
Is that right?
Yes.
At those receivers. And 54 at the top, and other figures, all right?
Yes.
What do you say about those levels with the acoustic barrier in place with an 8 dB penalty?
Well,
again,
with the 8 dB penalty, there, as you can see by building 3, those are even above the upper limit of 55.
What do you say about whether that's achieving a good standard of amenity, Mr. Davis?
Well, again, I wouldn't say that it is achieving a standard of noise environment amenity space, because again, they will be subjected to the operation of Benfleet scrap.
All right, and that's, again, just to close this point off, 58, 57 is with the 8 dB penalty if you attach 13.
It wouldn't, you'll be way over your 55 dB, and immediately that is unacceptable.
Okay, now that's Appendix D7. Yes.
Yes.
Can we go back a couple of pages to page 14, which is Appendix D5. And these are the, this one says Appendix D5, points map proposed mixed-use scheme, predicted noise climate, but there's no account taken for characteristic penalties on these figures. Is that right?
That's correct, yes.
Yeah. What do you say about the appropriateness of applying a characteristic penalty and using Appendix D5 on its own?
I think in terms of its assessment here, I don't agree with, because because of the characteristic of the noise within BS 8233, it says that you do need to take reference to measurement procedure of 4142.
So within BS 8233, it does say that you need to take account of BS 4142. That's where there is, 4142 is where there's industrial noise.
Industrial noise assessment. So you have to then take into account the noise makeup and add the penalties.
Yeah, and is that when it's dominant or when it's not dominant?
That's when it's dominant. So because you've got a dominant noise source, you've got to take that into account.
Yeah. So these figures we've got on Appendix D5 are without that characteristic penalty.
That's correct.
So just standing back from it, you've taken me to saying that 8233 says you should look at 4142 and 4142 factors in the characteristic penalty. Just as a matter of common sense, forget about what the guidance says, should you be applying a characteristic penalty or not?
As a common sense, if you're on site, you clearly hear a noise that is way above everything else, so it has to be taken into consideration.
Yeah. Okay, but notwithstanding that, if you were to use just these figures, all right, Appendix D5, so without looking at characteristic penalties, again, just in terms of Benfleet scrap and what's been assessed,
Yes.
we can see the crusher and 3 excavators.
Yes.
Yeah. So your points about the aluminium processor and the 4th excavator.
The 4th excavator have not been assessed as an additional noise sources.
Okay. And even if you don't account for those and you just go with the figures that are on here, let's just have a look at those. So you've got, again, the white boxes at noise receptor 3 and 5, levels of 50 and 52, 51, 52 and 50.
Those are the facade levels, yes.
Yeah. So again, allowing for... So at those facades and internally, what would you say about those levels?
Again, with the partially open window, that you 10 to 15 dB, the noise is still, you're on borderline with those, so that the noise will still be audible within those properties. Okay.
And then externally, all right, we can see levels of 49 and 50.
Yes.
And in fact, at the public open space, 45, I think. We're getting down to 45,
yes.
Yeah. Again, what do you want to say about those levels?
Again, you are borderline. You've got 50 dB, but again, the noise and operations from the industrial estate will be audible within those external amenity areas.
Okay. Can we... From there, please, just go to Miss Nixon's proof and look at page 25, please. Page 25 of Miss Nixon's proof. Now here we have, starting on page 24, unattended results, and we've got a table, yeah, with positions 1 and 2, which give us unattended results for broken down for licensed hours, daytime, and then overall daytime, overall nighttime.
Yep.
For position 1, which is the top half of the table,
Yep.
position 2 for the bottom half. Is that right?
That's correct, yes.
And then in terms of the columns, what we've got is the ambient noise, which is the LAEQ level,
Yep.
maximum noises, LA max levels, and background noise levels, LA 90s. Yeah.
Yes.
Just help me with LA max, the central column. All right, the central column. What are LA max figures?
Well, the max level is the maximum decibel level that's measured throughout that measurement period.
So it's the highest level, the
Yes.
maximum level that was achieved during the
According to
results.
here, that during the licensed hours, that was the loudest sound level that was measured during that period.
Yeah. And if we just look at the asterisks and what they mean, we can see that a couple of them, so there's one at 101 dB in the top half of the table,
Yeah.
but that's being discounted as an anomaly.
An anomaly.
Yeah.
Yeah.
And we can see in the bottom half of the table there's a 97 figure which has 2 asterisks. Yeah.
Yeah.
And that's said not to be by Benfleet. Yeah.
That's correct.
Benfleet
Yeah.
scrap. Sorry.
Yeah.
Yeah. So just discounting those for a second, the top row. So for licensed hours under position 1, we've got a LA max figure of 97 dB.
Yes.
Yeah. And then position 2 in the top row for licensed hours,
Yes.
we've got an LA max figure of 88 dB. Is that right?
That's correct. Yes.
What do you say about those levels against ambient noise levels or background noise levels?
Well, again, those levels are, as you can see, very elevated against your ambient, which is your steady noise throughout the measurement period.
Very elevated. So
Yes.
68 for the
So
ambient
you've got
noise.
68 for the ambient, and then suddenly you've got a loud noise of 97 dB.
Yeah. So in the order of what? 30.
Yeah,
30
so
dB
30
higher.
dB higher.
Yeah. And just what does that mean in the real world?
Well, in the real world, you'll be, after, let's say, an hour, you're getting used to your steady 68, then suddenly you've got a loud crash.
Yeah.
Most people will jump with that because it's so discernible over anything else.
Now that's the example you go. Is it the case that you only get the crashes once every hour?
No,
When you were on site, how often
this
do you
this
get
is a crash. You may have 90 dB and then 92 and then 80.
How often?
Well, throughout the working day.
Yeah.
and-
So
and
how often?
operation.
When you were on site, was it every few minutes, every few seconds, every few hours?
Those crashes and bangs was happening every few minutes while I was on site.
Thank you. And how is that different? So we've looked at characteristic penalties that are applied through 4142.
Yeah.
Yeah, which are of the order of, you're looking at 3s and 6s and so forth. How is that different, if at all, from LA max figures? Why are you saying this is relevant here?
Well, it's relevant because those are the general noise that's going to immediately be audible to somebody. So
Yeah.
it's such a large characteristic, it has to be taken into account. But 4142 and 8233 deals with average noise levels across a time period.
So just pause there. 4142, the assessment's looking at average noise levels.
Yes.
Yeah. Across a 16-hour period.
Yeah.
Yeah. And to that, you add a characteristic penalty.
Yes,
Yeah. When looking at the average level.
the average.
Yeah. So you increase it by 8 or 13 in your case.
Yes.
To look at the average. Yeah. This is an LA max figure.
Yes.
This is what you actually experience as the highest level that was assessed on the unattended site. Right. Okay. And so go on.
Yeah, so myself, but personally, a more appropriate assessment would have been a 1 hour LEQ, because that would have given you a greater indication of where these LA maxes are throughout the operation of Benfleet Scrap.
Have we got an LA 60 figure?
No, not to my knowledge.
And do we have any consideration of LA Max figures, apart from obviously the figures?
No.
Do we have any assessment of those? And
No,
significance?
there's no mention in both assessments of that they are noted in the tables, but there's no consideration as to the effects of those levels.
Thank you. So just in terms of your conclusions, what do you say about, whether it's Ms Nixon's analysis or the one that came in with the application, the V2 analysis, about whether they produce an acceptable noise environment internally and externally?
I think that both reports, in terms of have they followed procedures, that yes, they have to a point. How they've interpreted, especially Miss Nix, or both of them are saying because of the higher noise levels, those can be considered because the area is considered urban, which I disagree with. So generally, I don't think it's acceptable to be introducing noise-sensitive receptors into this environment.
Yeah. And when you say it's followed procedures to a point, okay, is that the point you were making about 8233?
Yes.
Should take into account 4142
4142
characteristic penalty?
Yes.
Right. And just to help me finally with real world impacts, I mean, what would it be like to be on this site in residential housing?
It will be noisy. It will be annoying. You'll be sitting out in your garden in the summer, and as I've said, over a period of time, you get used to a certain level of noise. But it's the bangs and the crashes throughout the working day that will be causing the issues.
Thank you. Anything else you want to add?
No.
Those are my questions as Examination in Chief.
Thank you. It's now 12:22, and so I think we should adjourn for lunch now. How long do you want? I'd allowed an hour in my programme. Do you want an hour? Yes? Okay, right. An hour it is then, so come back an hour from now, or say 1:25. Okay, thanks so much.